We are present in case 22 CR 000858. It is captioned State of Ohio versus Michelle Penn. The defense in this case has filed a motion to suppress evidence. Of course, scheduled this for an evidentiary hearing this morning pursuant to that motion. Defendant is present in court. She's with her attorney, Ms. Mary Springer. The State of Ohio is also present, represented by Assistant Prosecuting Attorney Carolyn Mulligan. Are both sides prepared to proceed here this morning?
Yes, Your Honor.
Yes, Your Honor.
All right, then I'll hear from the state first. Ms. Mulligan.
Yes, Your Honor. The state is prepared to demonstrate that there was probable cause to believe that the defendant was operating a vehicle while under the influence of alcohol when she was asked to take a chemical test, and that refusal subsequent to being asked is admissible. I offer the testimony of Officer Richard Isabella from the East Lake Police Department.
Ms. Springer?
Yes, Your Honor. Thank you. As we discussed in chambers, this is a very narrow issue that we are here for today, specifically as it relates to the defendant's alleged refusal of the chemical testing while she was hospitalized. The first issue is whether or not there was probable cause that she was intoxicated at the time of operating a motor vehicle, and the second related to whether or not she was arrested or charged with the OVI at the time that she allegedly refused the chemical testing. So we are prepared to proceed on those two issues today. Thank you.
Thank you. All right, Ms. Mulligan, you can call your first witness.
The state calls Richard Isabella.
Good morning. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Proceed, please.
Okay, yeah, that's good.
Only whenever you're ready.
Thank you. Sir, would you state your full name, spell your last name for the record?
Richard Isabella, it's Isabella.
And your occupation, sir?
Police officer with the city of Eastlake.
How long have you been a police officer with the city of Eastlake?
I'm sorry, I didn't mean to interrupt. We'll stipulate to his training and experience for the purpose of this suppression.
Accept that? No, you know,
I'm not going to go into it.
DUI stuff, we should probably set, should,
but
and alcohol stuff, we should
appreciate the offer.
Thank you.
probably address that.
Okay. How long have you been an officer with Eastlake?
Just over 28 years now.
Okay. And presently, what is your role at the Eastlake Police Department?
A row officer. I work the road.
And of those 28 years, how long have you been on the road?
Probably 20. I was in the detective bureau for approximately 9 years.
Okay. And a road officer, can you just briefly describe what your responsibilities are there?
Our responsibility is just to patrol the neighborhoods, look for crime, traffic enforcement, investigate accidents, investigate initial calls, crimes.
And when you do that, are you in uniform and in a marked cruiser?
Yes, I am.
Going to July 20th, 2022, were you working that day?
Yes, I was.
And were you in a cruiser and wearing a uniform?
Yes, I was.
And you're a certified peace officer in the state of Ohio?
Yes, I am.
In the 28 years that you've been a police officer, do you have any experience with operating a vehicle under the influence? Have you made arrests?
Yes, I've made
Can you say approximately how many?
several hundreds. I won the top cop award twice for MAD, Mothers Against Drunk Driver award through our department twice in my career.
Okay. And has that been consistent throughout the 28 years that you've been with the department?
Yes.
And can you let us know in the last couple of years how frequently you make an arrest on an OVI?
In the last couple of years, the OVI's arrests have been down, so approximately 10 to 15 per year, roughly, over the last couple of years.
You say the records are down. What is your experience with that?
There's more alternative avenues for people to provide rides home. Designated drivers, Ubers, Lyfts. So more people are more conscious about drinking and driving.
Nevertheless, you say that you have about 10 per year?
Correct.
And prior to that, did you have more frequent?
Oh, yeah, so it was more like 30 to 40 a year early in my career.
Now, going to July 20th, 2022, you were working, do you recall what shift you were working on that date?
We're on 12-hour shifts. I'm a permanent midnight shift guy, so I work from 6 p.m. to 6 a.m.
Okay. And was there a time that you received a call to a situation on Forest Drive involving the defendant, Michelle Penn?
Yes, roughly around 2 a.m. in the morning, we received a call of a single vehicle that struck a tree.
Okay. And you said that was around 2 a.m.?
Correct.
That you received the dispatch?
Correct.
Did you report to that location?
Yes.
And do you know how long it took you to get to that location?
I believe it was approximately 2.5 minutes.
Okay. And can you describe Forest Drive? That's in East Lake County, Ohio?
Yes, it is.
Let me stop. How did you receive the?
Dispatch.
How did dispatch receive?
A gentleman called, and a gentleman by Jim.
I don't need his name.
Okay. A gentleman called the dispatch and advised that he saw a vehicle struck a
So it
tree.
was a witness that saw this.
Yeah, but he did not want to give a statement.
Fine,
But
that's
yes,
how it was,
that's how we
the
received it.
department became aware of it.
Yes, sir.
Did you have any information about what that caller had said at the time you were dispatched?
Dispatch advised that the caller advised that he heard a loud screech and saw a vehicle struck a tree.
And you're familiar with Forest Drive there in East Lake?
Yes.
Okay. And what direction does that road lie?
Basically north and south.
Okay. And is it a straight road, a curvy road? How would you describe the road itself?
Different ends. One end's got a hill to it towards the lake. The other side, it's kind of level, but a slight grade downwards with a curve just before you get to Lakeshore Boulevard. So Forest Drive runs between Lakeshore Boulevard and the lake.
Okay. And when you did arrive 2.5 minutes after the dispatch, what did you see?
When I turned on the Forest Drive from Lakeshore Boulevard, I saw a white Chevy vehicle that had struck a tree with heavy front end damage.
Okay. And where was this tree relative to the roadway?
Approximately 300 feet north of Lakeshore Boulevard.
Okay. And
It
where
would have
was-
been on the east side of the roadway.
Okay. And where was it in relation to Forest Drive? Was it?
It was on Forest Drive. I mean, it was like, I guess you call the tree lawn area. So it was within probably 3 to 4 feet of the roadway.
Okay. And you described this road as being sloped and curved in some directions, in some spots. Was it sloped or curved in that particular spot?
It had a slight grade down in that location, yes.
What about curvature of the road? Was there a bend or a...
There was a bend, but the vehicle didn't reach to that bend.
Could you tell what direction when you first drove up there? Was it obvious to you what direction the car was coming from?
Yeah, the vehicle was traveling south.
Approach.
You may.
I'm handing you what's been marked as State's Exhibits 1, 2, and 3 of photographs. Could you look at those, please?
Yes.
Do you recognize those?
Yes, I do.
What are they pictures of?
There are pictures of the Chevy that struck the tree.
Okay. Do they fairly and accurately depict what you saw there on the 20th of July 2022?
Yes, it does.
Okay. And can you describe what State's Exhibit number 1 shows?
It shows a fireman attending to Miss Penn, who was in the driver's seat, with myself standing next to it.
And what about State's Exhibit 2?
State Exhibit 2 is the front of the vehicle showing where it struck the tree on the driver's side, front end.
And what about State's Exhibit 3?
State Exhibit 3 shows Miss Penn in the driver's seat.
And were you able to determine the extent of the damage to that vehicle as a result of striking the tree?
We believe it was disabled. It was undrivable.
Okay. What about the condition of the airbags? Did you make any observations of that?
Yeah, both front airbags were deployed.
When you first arrived on the scene, did you see any people?
Yes, when I first rode on scene, I could see the vehicle had struck the tree. I saw both front airbags deploy with 2 females in the front compartment of the car.
Were they still in the car, or were they coming out of the car? How?
They were both in the car when I first arrived, and then the passenger, Miss Banning, exit the car. I asked her, "Are you guys hurt?" She says, "No, we're okay," but I could see blood coming down the left side of her face, so I requested a squad immediately. I asked her to have a seat till the squad got there. She was pretty wound up. She didn't want to sit down. She kept moving around, and at that point, I walked over to the driver's side to attend to the driver.
And when you went over to the driver's side, who did you see in the driver's seat?
Miss Penn was in the driver's seat. I didn't see any visible injuries to her at the time, but I was just talking to her, asked her if she had any injuries. She said her right leg hurt.
And this Miss Penn, do you see her in the courtroom here today?
Yes, I do.
And would you point around?
She's sitting right over there with a black hoodie, zip-up sweatshirt.
If the record can show that he's
The record was
the defendant. Thank you. She said she was in pain.
She said yes, her right leg hurt.
Okay. How close did you get to her? There, talking to her.
The driver door was open. I was probably within a foot of her, looking at her to see if I could see any visible injuries and stuff. So, and when I was talking to her, I was within a foot at 1 to 2 feet of her at all times.
Okay. Did you see any visible injuries on her as she was sitting there?
Not as she was sitting there, but then when she told me she had injury to her right leg, she went to turn to get out of the vehicle. When she turned to get out of the vehicle, I could see that she had a bone fragment sticking out of the right leg just above the ankle area.
And did that appear to you to be an injury that she could walk on?
No, no.
What did you do when you saw that?
I requested a second squad for her. I advised her to stay in the car. She didn't want to stay in the car. She wanted to get out, but I advised her she couldn't walk, just to stay in the car.
You advised her that she couldn't walk?
Yeah, because her bone was sticking out, I advised just to stay in the car.
Did you make any observations about her demeanor as she was sitting in the car?
When I was talking to her, I could smell a strong odor of alcohol coming from her person. While she was talking to me, I saw the glassy red eyes. She had the slurred speech. I asked her how much she had to drink, and quoted, she said, "Not much."
The observations that you made as far as her eyes, her speech, and the odor, have you experienced those before? Have you seen that before in arrests that you've made?
Yeah, those are typical characteristics of someone under the alcohol influence.
And you asked her specifically what?
I asked her specifically how much she had to drink, and she quoted, "Not much."
What happened next?
I told her to remain in the car. The rescue squad arrived on scene. They transported Ms. Banning to Lake West Hospital. Ms. Penn was transported to Hillcrest Hospital.
And what did you do?
Eventually, after clearing the scene, I responded to Hillcrest Hospital, where I spoke to Ms. Penn. I read her the BMV 2255, which is a refusal consequence form.
Why did you go to the hospital to see Ms. Penn?
Follow-up investigations.
The investigation of what?
Operating a vehicle under the influence.
And about how long after she was taken away did you get to the hospital to talk to her, if you recall?
I don't recall, maybe 40 minutes, 30, 40 minutes.
Did you do the crash scene investigation?
I did not. Sergeant Weber and Patrolman Otala conducted the traffic.
So you weren't delayed by that process?
No, no.
I'm going to hand you what's been marked as State's Exhibit number 4. Do you recognize that?
Yes, that's the BMV 2255, which is the refusal consequence form.
And is that a copy of the form that you used specifically in this case?
Yes, it is.
Okay. And how do you know it to be that particular one?
My signature's on it.
And what about Michelle Penn?
Yes, when she was read the form on the back, she was asked to sign the form that she acknowledged that it was read to her, and she signed it.
Okay. And this form, you said it was read to her. How do you read it to her?
On the back of the actual form that's filled out, is a paragraph that we read to an individual who we believe are under the influence of alcohol or drugs or a combination of them.
Okay, do you read it word for word?
Yes.
Okay. And how does that begin?
The first line on it says, "You are now under arrest for," and it goes on to operating a motor vehicle under the influence of drugs, alcohol, drugs, or a combination of them, and it continues to go on.
And the purpose of that form, your understanding of the purpose of that form is what?
To advise them that they were under arrest for suspected of driving under the influence of alcohol or drugs, and were requesting to obtain either breath, urine, or blood.
Okay. And was that request made of Ms. Penn at that time?
Yes, we were requesting blood or urine because there was no breathalyzer machine available at the time.
Okay. And did she comply with that?
No, she refused to submit to any chemical tests.
Do you have a recollection of what she said?
No, I just asked her if she'd be willing to give blood, and she said no.
Okay. Did you talk to her there at the hospital about what was happening with the process here in terms of her responsibility for the...
Yeah, I tried to follow up if she knew what happened. She kept saying, I don't know, for most of the questions. After I read her the 2255, she refused to submit anything. I advised her that charges were pending, and we'd be following up with her in the future.
What do you mean by charges were pending?
She was not charged at the physical time of operating a vehicle under the influence. Based on, we had a follow-up investigation with the passenger, Ms. Banning, to see what the extent of her injuries were.
Did you take her into custody, Ms. Penn? Did you take her into custody that night?
No, she was in the hospital bed when I read her the form, and then when I left her in the.
Okay.
She was
Can you
the same
explain
place.
to us specifically why you did not take her into custody?
Because we wouldn't know the extent of the injuries to Ms. Banning for further charges. Plus, she had medical attentions on her, so we couldn't care for her medically if we took her into custody.
And then what was the last thing you said?
We couldn't care for her if we took her into custody and brought her back to jail. She was in a hospital.
Oh, if you took her into custody.
If we took her into custody and brought her back to the station, we wouldn't be able to care for her medical needs.
And you know that she was ultimately charged?
Correct.
Okay. When was she charged?
I don't have the specific date. After we got the results back from Ms. Banning's injuries, I was on vacation at the time. It was determined to go ahead and charge her with vehicular assault. And charges were, proper cause warrant was obtained. Ms. Penn turned herself in on the warrant, and here we are.
Would you have any reason to question that it could have been August 8th?
No.
Okay. If you recall, did Ms. Penn have any response to you telling her that charges are pending for a criminal activity that she had?
She said she understood, because when I gave her the copy of the 2255 form, and I gave her the total release for her vehicle, because we weren't keeping her vehicle, but I advised her, here's your total release, it was totaled. It appeared to be total. And here's your total release, and charges were pending. She said she understood.
Thank you. I don't have any more questions.
Thank you. 1 second, please. All right, cross-examination.
Thank you, Your Honor. Can you see me okay from here?
Yes.
Okay. Good morning.
Morning.
You indicated that you responded to the vehicle accident after receiving a call from dispatch, right?
Correct.
And so you never had the opportunity to witness Ms. Penn operating a motor vehicle.
No.
And the report that was made occurred after the accident occurred. Is that right?
That's correct.
And so were there any calls to dispatch on that early morning related to any reckless driving from this vehicle?
No, not that I'm aware of.
Did anyone call in to indicate that this vehicle was swerving or anything like that
No.
prior to the accident?
No.
Do you know where Miss Penn resides?
During my investigation, initial contact with her, I asked her where she was going, where she was coming from. She knew where she was. She kept saying, I don't know, I don't know, I don't know. Then she said, I said, you're familiar with the area? She said, no, I'm from Niles. And then Miss Banning heard us talking, and she yelled, we were going to her house, which is in Timberlake, which is the village right next to Eastlake.
Okay. So through your investigation or the discussions that you had with the defendant and the victim, you learned that the defendant is from Niles, Ohio?
Correct. That's what she told me at scene.
And you learned that the victim is from Timberlake?
Correct.
Okay. And so did you have an understanding of what they were doing that evening?
They didn't tell me. I could tell you what my knowledge is are from my experience.
Okay. So you didn't learn of an establishment that they were at or, a particular activity that they were doing, did you?
No, the gentleman who called in the accident there's a bar right down the street, probably less than 1,000 feet, called the Offshore Bar and Grill.
Okay.
The gentleman who called in the accident was on the front deck of that bar.
Okay.
So I couldn't tell you if they came from that bar or what bar they came from, but that's where the caller called from.
Okay. So when you're describing them possibly coming from a bar, that's based on your training of dealing with these types of offenses, that oftentimes people leave a bar and then get an OVI?
Not necessarily. They either, if they go to the bar and they're drinking and get involved in an accident, it's a good sign that either they were at a bar or at a resident drinking.
Okay. So you're not sure where they were?
No.
Okay. And you did learn that they were traveling to the victim's home in Timberlake?
Yeah, based on Ms. Banning saying that they live in Timberlake and the direction they were traveling, made sense that they were traveling to get to Lakeshore Boulevard to head towards Timberlake.
Do you know if Ms. Penn is familiar with the area? She indicated to you that she's not, right?
When I asked her, she just kept saying, I don't know. But then I asked her if she was familiar there. She said, I'm from Niles.
Okay. And so do you know how they were navigating?
I do not.
Okay. So you don't know if they were using a GPS?
No, I do not.
Or you don't know if Ms. Banning was giving Ms. Penn instructions on how to get to her home, right?
Correct. I do not know.
Okay. You talked about the street that the accident happened on. And we had an opportunity to see that picture there with the exhibits. Is that a reasonable route, do you know, to get to Ms. Banning's home, to take that street?
If you're coming from the Offshore Bar and Grill or one of the marinas, or there's two other bars down below the hill called the Sugar and River Tavern and the Castaway. So there's several liquor establishments in that general area that they could be coming from.
So my question is, the direction that they were traveling, like through the use of that road, that side street, is that the way that you could take to get to Timberlake?
No, if they were going north, it would not be. They could not get to Timberlake if they were going north on that road. No.
Okay. So, do you believe that they were turning off of Lakeshore Boulevard to get onto that street?
Objection.
Sustained.
Do you have any indication of which direction they were traveling in?
It appeared they were traveling south on that road from the impact of the vehicle onto the tree. When it first struck the tree, it hit on the driver's side front end, and the vehicle shifted towards the south. So that's an indication that the momentum was coming from north to south.
Okay. And so, this might just be because I'm not super familiar with that area, but were they is it your belief they were traveling south on that road?
Correct.
Okay, towards Lakeshore Boulevard?
Correct.
Okay. And that vehicle, the car did not make it to Lakeshore Boulevard?
Correct.
Okay, thank you. When you had the opportunity to speak with Ms. Penn and Ms. Banning, you described that Ms. Banning was wound up. What
Correct.
did you mean by that?
She was just moving around. She was, I don't know what you say, upset, but she was just very active. And I asked her to calm down, to have a seat, because she was bleeding, and I didn't know the extent of her injuries. She refused to sit down. At that time, she was moving around, so I went over to the driver to see what kind of medical attention she would need at that time.
Okay. And Miss Banning was yelling, right?
She was, I guess you could call it yelling, talking loud, because she just said that when I asked her if she's hurt, she just yelled, "No, I'm okay." But then when I was talking to Miss Penn over on the driver's side of the car, she was on the passenger side of the car still, and she could hear us talking. That's when she yelled out, "No, we were going to my house, and I live in Timberlake."
Okay. And she was visibly intoxicated.
Yeah, I could smell alcohol on her also, yes.
And Miss Banning, the victim, refused to tell you where they were drinking.
I don't believe I ever asked her.
You wrote a report in this case, right?
Correct.
Do you remember indicating in that report Patricia would not state where they were drinking?
I might have wrote it in there. If I wrote it in there, then that's what she stated.
Okay.
I don't recall it at this point. I don't have the report in front of me.
Okay. Would seeing a copy of your police report refresh your memory
Yes,
on that?
absolutely.
Your Honor, may I approach the
You may.
witness?
Yep.
If you could just glance over that.
Mm-hmm.
That's a copy of your report, right?
Correct.
And if you would just look through and make sure that it hasn't been altered in any way and it's a clear and accurate copy of the report as you wrote it.
Yes, it's pretty accurate. It's my report.
Okay. And if I could just direct your attention to the second page,
Mm-hmm.
I think it's the second paragraph down. Do you see there where you indicated that Miss Banning she refused to tell you where she was drinking that evening?
Correct. I cleared Hillcrest Hospital, responded to Lake West Hospital, spoke to Patricia. Patricia would not state where they were drinking, but did sign the medical release form.
Okay. And again, Patricia is the victim of this case, right?
Correct, Ms. Banning.
And when you wrote that report, that was closer in proximity to the time of the events that occurred.
Correct.
And so what you wrote in that report was your understanding at that time.
Correct.
I want to shift the focus a little bit more to now when you went over to the other side of the car and spoke with Miss Penn.
Mm-hmm.
You said that you were about a foot away from her, right?
Correct.
And that when she swung her leg out of the car, that's when you noticed the compound fracture, her bone sticking out?
Correct.
Okay. And so you told her not to get out of the car, right?
Correct.
And it appeared in that moment to you that she didn't know that her bone was sticking out of her leg?
Correct.
That's a pretty serious injury, right? You would agree with me?
I agree with you.
And that sort of injury can certainly cause, if you know, adrenaline to be pumping, things like that, right?
It could.
And so you described a a couple of other things that you noticed about the way that she was acting, such as having slurred speech, right?
Correct.
And Ms. Penn had just been involved in this serious accident, right?
Correct.
And you described that her eyes were red, right?
Correct.
It was nighttime.
Correct.
Were there any lights on the road? Do you know if there were any
Street lights?
street lights?
There is street lights in that area.
Okay.
I don't know specifically location-wise to that, but there are street lights.
And you described a strong odor of alcohol coming from her person, right?
Correct.
And so you don't know the circumstances necessarily of where that was coming from, whether or not she had a drink spilled on her, anything like that, right?
That's correct.
You didn't indicate that it was coming directly from her breath.
Correct.
And at that time, when you were witnessing these things, you weren't aware of the totality of her injuries, right?
Correct.
This was just very early on in that
Correct.
process. And you are aware that she went to Hillcrest Hospital, right?
Correct.
Are you aware that she was admitted to Hillcrest Hospital for 11 days?
No, I am not.
You discussed once you went to Hillcrest Hospital that you asked Miss Penn if she would provide blood for your investigation, right?
Correct.
At this time, was there any indication of what her injuries were?
Other than the leg injury, no, that was the only injury.
So were you aware if she had any head injuries or anything else going on at that time?
Not at that time, no.
And again, when asking her questions, she was answering in a way that she was saying, I don't know, repeatedly, right?
On scene, correct. Yes.
Was she answering?
Which is on the scene?
On the scene, she was, when I asked her,
Where are you talking about now?
I'm talking about at the hospital.
oh, in the hospital?
Was that different at the hospital versus the scene?
On scene, she kept saying she didn't know. When I got to the hospital, she wasn't saying really much of anything. I just read her 2255. She refused to submit to a chemical test, and she also refused to sign for a medical release form at the time. And then I just explained her the process moving forward.
So could you just describe a little bit about what was going on with her at that time in the hospital? Like what was happening medically? Were there a lot of doctors around assessing her? What was that scene like?
When I first got there, not necessarily it was doctors. I think there was more nurse and techs were stabilizing her, getting her situated in bed. I had to wait till they clear out before I can go in there. Once they had her stable, I went in there and read her the 2255 along with the Cleveland Clinic officer who witnessed it.
Okay. So the person that witnessed it was another police officer from the Cleveland Clinic?
Correct.
Okay. Was anyone else with Ms. Penn? Any loved ones, family members or anything? Or was it just her, you, and the Cleveland Clinic officer?
No, there was also medical staff in the room. I don't know who or what the titles were, but there were more than just the two of us in the room at the time.
Okay. And you indicated that Ms. Penn said that she refused, that she was not willing to give blood.
That's correct.
And how did she say that? Did she say...
I asked her if she's willing to submit to a chemical test, and she said no.
Okay.
And then same respond for the medical release. She just said no.
You also described whether or not she was in custody when you read her that form. And I think you indicated that she was not in custody, right?
We didn't take her into custody after I read her the 2255.
Okay. And I think that you described that you did not take her into custody because of her medical problems, right?
Correct.
Is that the reason that you also did not do field sobriety tests because of her medical problems?
We were unable to do field sobriety tests due to her injuries on the scene.
So how about the eye testing? Were you able to do that?
No.
Did her injuries preclude you from being able to do that?
My more concern at the time was as soon as I noticed her injuries, I had a squad come and By the time we got done, the squad was on scene. They first attention was to her medical health, so they transported her immediately.
How about at the hospital? Were you able to do that?
No.
A person certainly can be in custody and at the hospital at the same time, right?
That's correct.
Okay. And that was not the case here.
Correct. Just under.
What's your question again?
That-
Person can be in the hospital and in custody at the same time.
Yes.
Okay.
Yes, they can be.
Okay. And that was not the case here.
Correct.
You described informing Ms. Penn that there were charges pending against her, right?
Correct.
And that she indicated an understanding to you that she understood that there were charges, right?
Correct.
Did she understand, or did you relay to her specifically what those charges were?
No, I just I can't quote myself exactly, but a normal procedure would be to advise her that pending charges will be coming down the road. Do you have any questions? Do you understand? And she stated yes, she understood, and that was kind of my end of my interaction with her. It was very brief at the hospital.
So, having been in a motor vehicle accident, one such charge could be in relation to the failure to control a motor vehicle, right?
Correct.
So, indicating to her charges are pending, you didn't necessarily say an OVI is pending, right? You just said charges.
Correct.
Do you know how it came to be that Ms. Penn was charged with operating a motor vehicle under the influence?
I can only speculate what Detective Caroon
So why?
did.
So could you just explain that a little bit for the judge? What happened after July 20th?
Okay.
I'm going to object and said I can only speculate as to what.
What do you mean? What happened after July?
Well, he had mentioned Detective Caroon, so I'm just trying to figure out what he's talking about with Detective
I
Caroon.
guess you could testify in regards to what the next step in the investigation was. I'm not going to let him testify as to the detective's thinking. You're asking him. I want to rephrase your question in
Sure.
regards to the investigation.
Yes, Your Honor. After that early morning, what did you do next in your investigation? Was there continued investigation done?
Once I finished my report and my part of the investigation, I was going on vacation for 3 weeks.
Okay.
So the report was forwarded to another officer for follow-up so it doesn't sit. Detective Caroon, with his
What's his name? Caroon?
Chris Caroon, he followed up on it and eventually obtained the proper cause warrant based on, from the report, his supplements in there from the medical injuries that was Ms. Banning obtained from the accident.
So, in a report that you wrote on July 23rd, that is when you forwarded the investigation to your sergeant, Sergeant Weber, right?
Correct.
So that was 3 days after the incident occurred, the accident?
If that's the timeline, yes.
And so would you have any reason to dispute indicating in a report on July 23rd, forwarding it to your sergeant?
No.
Okay. And so then you're aware that your sergeant turned the case over to Detective Caroon, right?
He turned it over to Lieutenant Warner,
Okay.
who's in charge of the Detective Bureau, who in turn turned it over to Detective Caroon.
Okay.
Chain of custody there.
And you indicated that you were you were going to be going on vacation. So is that why that process happened?
Correct. Normally, the arresting officer would normally do most of the follow-up, unless you're a permanent night guy. Most businesses are closed during the night, so an officer on day shift or somebody from the Detective Bureau would do the follow-ups.
Okay. And so when was the OVI charge filed? It was never filed through you, right? You didn't write a ticket for OVI, right?
I did write a ticket.
You did?
I completed a citation, okay, and the citation was sitting there
When
because
did you do that?
that night I completed the site
After the hospital?
after the hospital. I always complete it ahead of time, but it wasn't served. I just write it out, and because I was going on vacation, so I had it written out, and it was left at the police station along with the report pending further investigation. If there was additional charges, which there were, once they obtained the probable cause warrant, she was served with the probable cause warrant for the aggravated vehicular assault. At that time, when she was arrested on that, she was served a citation for the traffic violations.
The one you wrote?
The one I wrote. Yes.
Where did you write that, if you remember?
It
Was
had to be, no, it would have been at the station. I didn't write it, that citation at the
So
hospital.
after you left the hospital, went back to the station?
Completing all my paperwork for future follow-up, yes.
And so, you described that Ms. Penn was not served with that ticket, right?
Correct.
So you didn't, rip off half of it and say, okay, here's your charge.
No, ma'am.
Okay, so it was sitting back on your desk pending the investigation.
Correct.
Was it pending the investigation of potential lab results of Ms. Penn?
No, it was pending on, because she refused, so there was no waiting on her results. It was based on the severity of the injuries to Ms. Banning, if there was going to be additional charges for an assault, vehicular assault, for Mrs. Penn's action for driving the vehicle, which caused injuries to Ms. Banning.
Okay, but you could have charged Ms. Penn with the OVI, and then those additional charges for vehicular assault, aggravated vehicular assault, those could have been filed later, right?
That's not our practice. We file it all at one time.
Okay.
So the normal practice, and it's not just for the OVIs, for hit skips are similar too. The citation will be completed pending further investigation if the officers are going to be unavailable in the near future for someone else to follow up with it, because that officer won't necessarily be able to sign the citation. On the citation, there's a spot on there where the investigating officer sign, and then whoever issues the citation would sign the bottom as the issuing officer and the date it was served.
Well, then what, let's assume for argument's sake that the defendant wasn't injured. No injuries at all.
Then she probably would have just been served the traffic citation.
You would have given her the OVI citation? So she would have been charged with it
Yes.
so you wouldn't have waited.
Correct. If there was no other pending circumstances, she would have been served.
No. Let's assume the passenger was still injured like they were. You didn't know the extent of those injuries.
Mm-hmm.
So you had to wait to see.
Correct.
I guess you said when there's in these circumstances, your policy is to wait to see what the injuries are so you can charge them all together. Correct. So my question is, if the defendant wasn't hurt, would she have not been charged that night? You still would have waited, or would you have taken her into custody? I mean, that was speculation, but
I get just a similar incident if I had a single car accident and the driver by themselves, they got transported to the hospital. I believe they were under influence.
No, that's not.
Okay, I'm trying to understand.
The same exact scenario we have, but the driver wasn't hurt. Nothing was wrong with the driver. Nothing was wrong with this.
No. It would. There was.
But the passenger was seriously injured.
Still be same circumstances. We would have held on to the charges. She wouldn't have been served
You would have
until.
let her go that night?
Pardon?
You would have let her go that night?
Yes.
You wouldn't have been arrested?
No.
So what about an administrative license suspension then? How do you deal with that? Because typically when a person refuses to give a chemical test on an OVI, they're immediately given an administrative license suspension, right?
They're served with a copy of the suspension. I couldn't answer how that process worked. I'm not in the administrative part of that.
Okay, but you in part make them aware that they are being administratively suspended because of their refusal, right?
That's explained on the back of the citation, the back of the 2255, correct?
So was that done in this case?
It was explained to her, yes.
Okay, so was she then given an administrative license suspension at the time at the hospital?
I don't recall if she was given a copy of the 2255 at that time. I believe normal practice would have been when she got served a citation, she got served a copy of the 2255, which would go into effect of the suspension at the time she was given a copy of it along with the citation.
Okay.
It was all pending investigation.
Okay. You cannot write up an aggravated vehicular assault on a ticket, right?
Correct.
So the policy that you're describing Eastlake Police Department having waiting to serve a ticket on a person to see if more serious charges are going to be pending, those charges aren't going to be added on to the ticket, right?
Correct.
Okay. So when the department applies for a probable cause warrant to be issued by the court, is the department also asking for probable cause to be determined on the underlying offense, like the OVI in this case?
You have to read the affidavit that Detective Caroon completed.
Okay. Are you familiar with the affidavit?
I know that we completed them and stuff. I don't know it. I saw it in my report, but I don't recall the wording on it.
If I showed you a copy of that affidavit, would you recognize it?
Yes.
Okay. Your Honor, may I approach the witness? So that's a copy of the affidavit that Detective Caroon applied for at the Willoughby Municipal Court, right?
That's correct.
And you have seen that document before, right?
Yes.
Because it's included amongst the case file, right?
Correct.
Okay. And in that affidavit, he is applying the Willoughby Municipal Court to charge Ms. Penn with aggravated vehicular assault, right?
Correct.
And in that, he also describes charges of operating a vehicle under the influence, right?
Yes, he based it on my statement and my report of the strong odor of alcohol on her breath, glassy eyes, and slurred speech.
And so after the Willoughby, are you aware that the Willoughby Municipal Court granted that?
Yes, I
Your
am.
Honor, I'm going to object to this line of questioning. She's asking him about things that he doesn't have direct knowledge of.
So you're aware that the Willoughby Municipal Court granted that affidavit, right?
That's correct.
And so at that time, the aggravated vehicular assault was filed, right?
Correct.
And are you aware that after the granting of that affidavit, that's when the operating a motor vehicle charge was filed as well?
I believe once she was served with the proper cause warrant is when she was issued the citation.
Okay. And are you aware, you indicated that Ms. Penn turned herself in for that, right?
I believe that's one of the stuff I read that she came in, she was advised, she was called by Chief Reich that the warrant was issued, and I believe they got her a personal bond, and she came in, turned herself in, and it got processed, and it was given a court date.
So did you know that it was immediately after she was discharged from the hospital that she went to the police department for the
No, I don't know the timeline on her.
May I have just a moment, Your Honor?
Right.
I have no further questions.
Direct examination.
At the scene of the crash, the defendant admitted she'd been drinking.
That's correct.
She smelled like she'd been drinking.
That's correct.
Her eyes were glassy and red,
Correct.
correct? And her speech was slurred.
Correct.
Did the appearance of her eyes and the sound of her speech indicate to you that she was under the influence of alcohol?
The smell of the alcohol made me determine that she was under the influence of alcohol. The red glassy eyes and the slurred speech could have been contributed to, I guess, other things other than alcohol, could have been drugs or whatnot. But the smell of the alcohol, along with the other two characteristics, yes, makes me believe she was under the influence of alcohol.
I'm sorry,
Oh, it made me believe that she was under the influence of alcohol.
okay. And the tree was not in the middle of the roadway, correct? The tree was in the grass off the side.
It was actually on the left side of the road, so I had to go left to center to hit the tree.
And the car went head on into the tree, correct?
Driver's side, front end.
I have no more questions.
Any recross as to that
Yes, Your Honor, briefly. It's not a crime to drink and drive, right?
I think that's a matter of opinion.
At the same time?
No.
Oh.
It is, that was confusing, Your Honor.
I think that is.
It is a crime to operate a motor vehicle while under the influence of alcohol, right?
That's correct.
And so we actually have levels of alcohol that make it illegal to be operating a motor vehicle, right?
We have a level that is sustained to an OVI, but under physical control, it could just be operate a vehicle under influence.
So theoretically, it is possible to have a few drinks, be under the legal limit, and be allowed to operate a motor vehicle, right?
Based on individuals, persons' drinking habits, weight, size, food. I mean, there's a lot of variables in that. So the answer to that, if I want a yes or no answer, would be, it depends. It's no.
So my question is, you can have a couple of drinks and be under the legal limit and operate a motor vehicle and have that not be a crime.
I don't believe that applies to everybody. It varies. You could have a couple of drinks and a person still could probably be over. I don't know the scientific behind all that.
That's not what I'm asking. If you know that a person is under the legal limit, that is not a crime, right?
The only way you're going to know if they gave a chemical test. Other than
That's
that,
what I'm asking you. Okay.
that's the only way you'd be able to tell.
That's what she's saying.
Yeah.
If someone took a test and they're 0.05, that wouldn't be a crime.
It would be a crime. It just wouldn't be
OVI.
It wouldn't be OVI. It'd be physical control. Operating a vehicle under the influence of alcohol doesn't have to put you over the legal limit. It just has to be under the influence.
So it's your position that
That's true. No, that's true.
if a person is under 0.08 and is operating a motor vehicle, that's a physical control?
Correct.
Okay.
It also could be an OVI.
So you don't know Ms. Penn's level of intoxication from this evening, right?
Correct.
Okay. And so when she indicated to you that she had a couple of drinks or a few drinks, that wasn't necessarily her saying, I have had enough to be over the legal limit or anything like that, right?
She didn't say a couple of drinks. She said not much.
Okay.
So define not much to you or me or her is different.
Okay. So she said not much.
Correct.
About how, as your experience as a law enforcement officer, about how many motor vehicle accidents occur in Eastlake annually?
Oh, we probably average 30 plus a month.
Okay.
So 350 to 400 plus a year.
So, and how many of those are directly related to operating a motor vehicle under the influence?
I wouldn't have those numbers.
Being in a motor vehicle accident is not necessarily evidence or not necessarily an indication that you are operating a motor vehicle under the influence. They are not synonymous with one another, right?
Correct. When the officer investigates and finds possible impairment, that's when the under influence comes in play. The accident by itself only is an accident.
So people get into accidents without being impaired.
Correct.
Nothing further.
Let me step down. Thank you.
Thank you, sir.
Statement costs next witness.
The state rests, Your Honor.
Move for the admission of the 4 exhibits.
Yes.
Any objection to 1 through 4?
No, Your Honor.
So states 1 through 4 will be admitted. Does the defense have any witnesses that intend on?
No, Your Honor.
All right, and let me hear from the state of Ohio. Any closing comments?
People do get into accidents all the time without drinking. But smelling like alcohol, admitting that you're drinking, having glassy eyes, slurred speech, and driving head-on into a tree that's off the road at a speed sufficient to deploy the airbags, I think that's reasonable to assume that the person was under the influence. A straight road, street lights, head on into a tree. the state has demonstrated there was probable cause to arrest the defendant for driving under the influence that night, and that the officer took reasonable steps to inform her of her arrest, her responsibility for the crime that he could determine at that time. It's responsible to wait to see what additional charges there could be. It's also responsible for him to say, we don't need to take her into custody when her bone is sticking out of her leg. All the indicators of arrest are there. The probable cause, the informing her with the 2255, you are under arrest for OVI. You have the opportunity to take a test. Charges are pending. Someone from the police department will bring them to you and tell you when they're filed. It couldn't be clearer that she is, in effect, under arrest. To say that she has to be taken to a cell or somehow have her physical liberty taken from her at that moment, she's clearly been informed of her responsibility for the criminal activity.
Thank you, Your Honor. In this case, we're talking about a defendant who is in an unfamiliar area, that she is from Niles, Ohio, and is in the Eastlake area in the dark at 2 a.m. with an intoxicated passenger. She is traveling in a way that it's unclear where she was coming from. And after this accident happened, she sustained serious injuries herself. Her bone was hanging out of her leg. There was described as a smell, the officer indicated smelling a very strong odor of alcohol on her person, again, not from her breath, that some of the injuries that she had were unknown at that time to the officer, and that she had a significant amount of medical care, that she had to be taken to Hillcrest Hospital to deal with the significant injury that she had. While the officer was at Hillcrest Hospital, she was not arrested, she was not charged, and although she may have been told, you are being arrested or you are being charged, that didn't happen. And as a person who is very injured, having to decipher what exactly it is that is happening at that time, I would argue that was very difficult to discern. The officer described that there was a need for additional follow-up, but that additional follow-up was not related to operating a motor vehicle under the influence. That Ms. Penn could have, at that very moment, been served with a ticket for an OVI or for a refusal, and it would have been very easy for her to understand, you are being charged with this. And so when a probable cause warrant is sought from the Willoughby Municipal Court, it was only at that time, after the determination by the court for probable cause, that the charges were then filed. And so I would argue to the court that her alleged refusal of this test should be suppressed. Thank you, Your Honor.
Just that driving in an unfamiliar area does not cause someone to go left of center, over the curb, onto the tree lawn, and head on into a tree.
All right, you can brief break now.
All right.
All rise. You may be seated.
All right, we are back on the record at this time. Court had the opportunity in this case to consider the testimony that was presented, the exhibits that were admitted, the briefs involved in them, and the research as well. Basically, if we're going to make the following findings. There's two issues involved here. The first issue involves whether there's probable cause to believe the defendant was under the influence of alcohol, and thus arrest the defendant if that was the intention. And in regards to this first issue, the court finds that there's more than enough evidence to constitute probable cause in this case. And in this case, you have the defendant who was out driving at 2 a.m. in the morning. She goes off the roadway, hits a tree head on with her vehicle. On arrival, police testify that there's an odor of alcohol, red, glassy eyes, slurred speech. There's an admission to drinking. She also sustained a horrific injury. She's got a bone sticking out of her ankle, and it appears based on the evidence she didn't even know it or realize it. Those factors, when looking at the totality of all those circumstances, clearly constitute sufficient probable cause to suspect the defendant was under the influence of alcohol. While each individual factor could have its own explanation as to why it exists. Yeah, sure, alcohol could have been spilled on the person's clothes. Maybe the eyes are red because of the accident that occurred. That's not the way this works. If that was the way it worked, we would never have probable cause. Because every single case, you can say the person could have had alcohol spilled on their shirt. So that's the reason for the odor of alcohol. And that's not the way this analysis works. It doesn't have to do with absolute certainty that it was because of that. You look at all the circumstances, you look at it together, and does that provide the basis? And it clearly does here. So the court has no issue with there being sufficient probable cause to suspect the defendant was operating under the influence of alcohol. The second issue is a little more complicated. The defense is seeking to have any evidence of the refusal, seeking to preclude any evidence of that refusal to be admitted at the trial in this matter. In support of their request, they've cited a couple of cases, State v. Rice, State v. Rawnsley, R-A-W-N-S-L-E-Y, for the proposition that a person actually has to be placed under arrest in order for implied consent law to kick in. And if they're not, and they read that form, then it's not valid because they didn't have to provide it, submit to a test under those circumstances, unless a refusal would not be admissible. And again, the defense submitted a couple cases to support that. Under very similar circumstances, a case where the person was involved in an accident, brought to a hospital, and presumably the reason why the arrest didn't physically occur was because the person was injured in the hospital and getting treatment. In fact, one of these cases I read, maybe it was another case, even talks about how there's even legitimate concern because of the expense that could be involved in those circumstances, where the police department would have to incur not only necessarily the expense of the treatment, but also have someone man there 24/7 to take care of someone, and recognize that's a reason why it wouldn't happen. And nonetheless, it's not an arrest. Now the state submitted a case to the court, State v. Volpe, V-O-L-P-E, which questioned that. Ultimately, the case found that it didn't matter. It would have been harmless error. The allowing of the evidence of the refusal. In that Volpe case, the court of Volpe cited State versus Arnold. And the court went on to question the Arnold decision, because the Arnold decision, the defendant in Arnold relied upon Arnold for the proposition that pre-arrest refusal, as opposed to post-arrest refusal, is not admissible to prove consciousness of guilt. You can sort of see how the Volpe court takes maybe a shot at the Arnold court, saying with very little analysis, they held that pre-arrest refusal to submit to chemical testing is not admissible because it is not based on consciousness of guilt, and we question that holding. I question that holding. How is that holding the 11th District Court of Appeals? And in Arnold, I mean, it's very simple. It's last paragraph of Arnold. We conclude that when one not yet arrested refuses to submit to chemical testing, the refusal is inadmissible. It's not based on consciousness of guilt. This case is from 1992. I'm not saying that's old, but 30 years. That's an 11th District case. And there's another 11th District case that came upon State v. Robeson, R-O-B-E-S-O-N, 2000 P0013, rendered in 2001. Very similar facts. Person was in an accident, went to the hospital, bloodshot, glassy eyes. At the hearing, he testified he did not place the appellee under arrest, but only issued a citation. There wasn't even a citation issued here. He read him the implied consent form, informing him that he was required to submit to a blood test, subject to his license being suspended. This case doesn't focus on the admissibility of refusal. It focuses on the imposition of the ALS suspension because they refused. So it's the same analysis. It's just the result of the refusal is different. And in this case, there were two issues that were raised. Weren't any of these. The court, 11th District, says we address neither of these issues because the fact that the appellee was never under arrest is dispositive of the appeal. An arrest exists only if there's an intent by the officer to arrest a suspect under real or pretended authority, accompanied by an actual or constructive seizure of the detention of the person, which is understood by the person. In the instant case, Trooper Sprigg testified the appellee was not under arrest at that time. Thus, the appellee's refusal to submit did not trigger the suspension of his license. So, what I want to do is give each side an opportunity to further brief this issue in light of the two cases I pointed out. Certainly, in the Volpe case that was cited by the defense, they talk about how there's cases on both sides. I haven't found a lot of cases on both sides. That's the reason, part of the reason why. Actually, it was one of the cases cited by the defense. I'm sorry, that talks about that. In the Rice case, the officer admitted, and it was very similar again. When the person went to the hospital, the officer admitted that they did not arrest the appellant at the scene, did not arrest him at the hospital prior to reading the implied consent form. Some jurisdictions have held that the oral reading is sufficient to constitute an arrest, and you cite a case there. This case said it wasn't. case cited by the defense says that's not enough. But the fact is we have two 11th district cases here, albeit both of them are, one's 30 years old, one's 20 years old, but I haven't seen anything, I didn't come across anything. Now, I spent some time, but not a lot of time, and maybe there's other stuff out there. And I want to give the sides an opportunity to research it further, because even though there may be different jurisdictions that go both ways, there's two 11th district cases here that go one way. So I'm going to give you an opportunity to further brief that issue. The first issue I've resolved, in your objections, that's noted. So I don't need you to address that. It's clearly the second issue. And if you need those, the Arnold case is cited in. Well, that's 92 P0046, 1992. So how long would you? I'll give you what you need. I'm not looking to make it to rush this. I'm not saying making you drop what you're doing and get it done. How much time would you like? I want to both do it at the same time. I don't want one file and someone get an opportunity to respond to that. So,
A week, 2 weeks.
I'll give you more than a week. Maybe at least a couple
Maybe
weeks.
10 days.
I'll give you 2 weeks.
Okay.
2 weeks from tomorrow. So, where are we at? March 3rd. Quite frankly, turn up the microphone. I'm gone following week, so March 10th they can be due. I'm going to be off the following week, so that's a waste of it. All right? Any questions about that? All right, thank you all.
Thank you.
All rise.
Understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk with your lawyer so you could ask your questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Well, let's get started then. How old are you, sir?
I'm 26 years old.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Have you prescribed medication? Nothing?
No.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing?
Yes.
You had a chance at some point to look that over?
Yes.
Now, in that information, you are charged with 2 counts. And count 1 here, what's alleged, and this is what you'll be admitting to, is on or about November 16th, 2022, in Willoughby Lake County, Ohio, that you did purposely or knowingly and with sufficient culpability for the commission of the offense of robbery, that you engaged in conduct, if successful, would constitute a result in the offense of robbery. And now let me explain to you what the offense of robbery is so you can get a better understanding of what the attempted is. 2911.02A3 is the robbery section. That's the underlying offense here. And what this offense prohibits is any person in attempting or committing a theft offense or in fleeing immediately after committing or attempting to commit a theft offense using or threatening the immediate use of force against another person. So that's what robbery is. You're charged with, or pleading guilty to, I should say, of engaging in conduct that, if successful, would result in the offense of robbery. You understand the difference there?
Yes.
And now another significant difference is the robbery charge is a felony of the 3rd degree, where this charge is a felony of the 4th degree. The robbery charge would carry with it a possible prison term of 3 years, where the maximum sentence on this count is 18 months. You understand the difference there?
Yes.
Any questions between the difference, about the difference, or in regards to what you're pleading guilty to?
No, sir.
Now, count 2, what's alleged here is on or about that same day, November 16th, 2022, in Willoughby Lake County, Ohio, that you did purposely by any means or knowingly by damaging or tampering with property substantially impair the ability of law enforcement officers, firefighters, or rescue personnel, or emergency medical services personnel to respond to an emergency or to protect and preserve any person or property from serious physical harm. That conduct constitutes the offense of disrupting public services. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes.
Any questions about that charge?
No, sir.
So you understand the nature of the 2 offenses you're pleading guilty to?
Yes, sir.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first off have this right to have this case presented to a grand jury. So the document that I just read to you, that information, again, it's called an information. What that is, it's criminal charges that are brought by the prosecutor's office without this case having previously been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that a person committed a crime. Probable cause is defined as some evidence to suggest the person probably committed a criminal offense. Now, everybody in the state of Ohio here accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in this decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor, or I should say charges brought by the prosecutor and the information. And your attorney has indicated she believes that's what you want to do. Is that correct?
Yes.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here a document called a waiver of indictment, which sets forth what I just explained to you about this grand jury process, and that you want to give that right up. Before I can go any further, I need to be assured you understand what's in that document. and that you signed it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes.
Mr. Carroll, is that accurate? Did you read that over, plan to review it with him?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did so?
He did.
Is that correct, Mr. Dan?
Yes.
Any questions for me about what it says?
No, sir.
All right, then I will make this document part of the record. At this point, I'm going to review with you all the other rights you have that you are giving up by pleading guilty. And you first of all have a right to have a trial. Now, a trial can be to me as a judge, where I listen to the evidence, I will make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And that would be in front of 12 citizens here from Lake County who would sit and listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors will make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. And what that means is all 12 jurors would have to agree together, one way or the other, as each charge, whether you're guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial in this case?
Yes.
Now, if we did have a trial, you would have the right, the prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. Now, by her having the burden of proof, what that really means, it's her job. She bears the responsibility or the obligation. She bears the burden of proving you guilty at a trial before you could ever be found guilty. You are presumed innocent of the charge. Presumption of innocence sticks with you and stays with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak of that burden of proof, hang on one second. When we speak of that burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that's the highest burden there is in our justice system. What it actually means is the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that, if we're going to have a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We'd call that cross-examination. So she would be allowed to ask them anything she wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that will come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come in court and testify for you if you wanted to and answer your lawyer's questions. Though you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes.
You realize you're giving up that right.
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
So since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness and force you to get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we did go to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it, or that's someone else's fault, or anything like that. Do you understand that?
Yes.
Excuse me. Further, as a result of pleading guilty, the effect of that guilty plea is that you'll be found guilty by the court of these 2 charges, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as possible sentencing goes, you are pleading guilty to 2 felonies of the 4th degree. Each of these offenses carry with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, since there are 2 separate charges here, if the court determined that a prison sentence was appropriate, I would impose a prison term on each count. And then as the judge, I have the discretion to run those sentences either concurrent with each other or consecutive to each other. Concurrent means you serve them together at the same time, whereas consecutive means one after the other. You serve the term I impose on count 1, finish that, then serve the term on count 2. You understand the difference there?
Yes.
So in this particular case, if I were to impose the maximum prison sentence on each count and run them consecutive, you're looking at a maximum possible prison sentence for these 2 charges of 3 years in prison. You understand that?
Yes.
Now, do you have any other charges pending against you right now anywhere?
No, sir.
Are you on probation or parole to other agencies?
I'm on parole through Cuyahoga County.
Post-release control? Post-release control?
Yes.
I need to advise you that if you're on post-release control and commit a new felony, the judge who is sentencing you for that new felony does have the discretion at the time of sentencing you for the new case to terminate your period of post-release control and impose an additional prison term of either 12 months or the maximum amount of time you have left on post-release control, whichever is greater. How much longer do you have in post-release control?
I think 2 years.
For whatever period of time is left, I can sentence you up to that amount of time in prison for that many months. And it would have to be served consecutive to whatever prison term is given to you for these 2 charges. You understand that?
Yes.
So if it's 2 years, you could ultimately be looking at 5 years in prison. You understand that?
Yes.
If it's more than 2 years, it could be more. Whatever amount of time is left, we would figure that out. But I don't know that off the top of my head.
Yes, sir.
How long will you put on post-release control for?
3 years.
We were just let out a few months ago, right?
It's a little over 2 years.
So you understand all that?
Yes.
Now, if a prison sentence were imposed in this case, upon your release from prison, you could be placed on what we call post-release control for this case. It's not mandatory in this case, which it would have been with the felony of the more serious robbery charge. It's discretionary, possibly 2 years, and I have nothing to do with that if it's a parole authority to decide that. You understand that?
Yes.
If you are put on post-release control for this case and you violate any of the conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, whatever the prison term was imposed by this court. You understand that?
Yes.
Now, in addition to the possible prison sentence that I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. Each count carries with it a possible fine of up to $5,000, so you could be fined up to $10,000. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
You could also be ordered to pay restitution if that's applicable to the victim for any economic loss any victim may have suffered as a result of your conduct. Do you understand that?
Yes.
Now, a few moments ago, I did explain the possible prison sentence you face. I used the word possible because prison is not mandatory in this case. You are eligible for probation, what's referred to as community control sanctions. Do you understand that?
Yes.
Now, do you understand that just because you're eligible doesn't mean you will automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented to the court, and I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of your probation. You understand that?
Yes.
Further, if you're on probation in the court and you're violating any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, you could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, again, it could be 6 to 18 months on each case, each count, I should say. It could be consecutive, so possibly 3 years. Do you understand that?
Yes.
Lastly, Mr. Dan, when we come back here for sentencing, you will have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the attorneys have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to follow that if I didn't think it's the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here today?
No, sir.
You understand all the possible consequences?
Yes, sir.
You still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer, have her review the report with you, discuss the issues, and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your attorney?
Yes.
Has she, or has anyone for that matter, made any promises to you about what's going to happen at the time of sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering this plea freely and voluntarily?
Yes.
All right, then do you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
You need any more time to talk with your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I need you to listen to what she has to say, tell us some follow-up questions for you, all right?
Yes, sir.
Ms. Linden?
Thank you, Your Honor. Your Honor, had we proceeded to trial, the state would have submitted evidence to show beyond a reasonable doubt all those statements and portions of counts 1 and 2 that have been set forth by the court already, and that specifically on November 16th, 2022 in Willoughby Lake County, Ohio, the defendant was at Carrie Warner, the victim in this matter's apartment. She had noticed that there was some money missing from her account and accused him of taking that money. He became upset. According to the report, he jumped on top of her and she started yelling for help. She attempted to use her cell phone to call the police, and the defendant told her that he would beat her up if she yelled for help. He then took her cell phone and wallet and left the apartment. So my understanding is that her phone was not found until later. It was found somewhere in the snow. There was some damage to that. Various parts of her wallet were strewn through several other places. They were able to locate some of it, but there was damage to the phone. And the victim in this matter actually had to ask a maintenance worker to use his phone to call for help.
Mr. Dan, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial in this case?
Yes.
What is anything you have to say about those facts that she presented them? Are they true? Did you do what she said?
Most of it, yes.
What's not true?
The fact that the phone had damage to it, the fact that I didn't get on top of her and do that.
Tell me what happened next. That's pretty much what happened. Tell me what happened here.
The night before, I took $20 out of her bank account to buy cigarettes, and she seen the next morning, and we got in an argument about it, and she told me to leave. I didn't have nowhere else to go, And I snatched her phone out of her hand, and I left the apartment with her phone in her wallet. And I left her phone right outside the door. And the police called me when I left on my cell phone, and I told them where the phone and the wallet were. And she recovered it, and it was the phone she still uses to this day.
Well, if you don't admit that there was a physical altercation.
Well, you're being charged with attempted robbery here, which means, let's go back to that. Because
It's not true, man.
Then we're going to trial on the two.
She's over there shaking her head, saying that nothing this stuff never happened, and she's over there saying that shit herself.
did you use or threaten immediate use of force against her in committing the theft offense and taking the wallet and the phone?
We will have the two if we don't have this. She has kept
So
her
what did
story
I say?
safe.
Did I say yes?
Yes.
Yes. I threatened.
Very well, then regarding count 1, charging with attempted robbery, a felony of the 4th degree, what is your plea to that count?
Guilty.
In regards to count 2, charging with disrupting public services, a felony of the 4th degree, what is your plea to that count?
Guilty.
All right, I have in my possession here at this time a document. It's 5 pages long, which sets forth basically everything I just explained to you about your rights, possible penalties you face. Before I can accept your plea, I need to be assured to understand what's in this document that you signed it here in open court. Now, my understanding is, again, before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Ms. Carroll, is that accurate? Did you read this over with Mr. Dam and review with him?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Dam?
Yes.
Do you have questions for me about what it says?
No.
Now, I'm looking at this document on page 4. There's 2 lines, it's signed and dated, and then has Justin Dam's signature of defendant. Now, it has the date where it says Justin Dam's signature of defendant, and it has what appears to be your signature on the line that says signed and dated. So it looks like it was in the opposite, but did you in fact?
Yes, I accidentally signed on the wrong line.
I'm sorry?
I accidentally signed on the wrong
Did you
line.
sign where the date was supposed to go into the date where you're
Yes, sir.
But you did that?
Yes, sir.
And you did sign this?
Yes.
You witnessed that, Ms. Carroll?
Yes, Your Honor.
Ms. Linden, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer. Advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, attempted robbery. Find the defendant guilty of a lesser included offense of count 1, being attempted robbery, a felony of the 4th degree in violation of 292302 and 2911.02A3, as well as count 2, disrupting public services, a felony of the 4th degree in violation of. It's not a lesser included.
It's the information. That was the charge.
It's not a lesser. It's a lesser included of what was bound over.
Yes, Your Honor.
But in regards to the information, it is count 1, not the lesser included offense of count 1. It is count 1. I was thinking in regards to the charge that was bound over. So let me start over here. I find the defendant guilty of count 1, attempted robbery.
Since they dropped my charges down, why are they going off of my first charge?
No, so it's not. That's why he corrected it. He was originally saying it was a lesser included.
But he's gonna sentence me off of that.
Well, no, we can only see the original charge, but what you're being sentenced on is just the 2 charges that were pled to today.
You have any questions for me, Mr.
No, we were just clarifying that it wasn't a lesser included, that it was.
It is lesser included of what the charges that you were originally arrested for and bound over on, and the charges that would have been presented to the grand jury. But since you pled by way of information based on discussions, plea negotiations that your attorney had with the prosecutor before this is how they worked it out. So I misstated when I said lesser included. It is a lesser included of what was bound over. If this would have been indicted as a robbery, felony of the 2nd degree, whatever offense it would have been, more serious offense, and then you pled guilty at this point, it would have been a lesser offense because you were already charged in the indictment. Since it hadn't been indicted, it's just semantics, really. It's not being referred to as a lesser included because it's an information. But it is a lesser included offense of what was bound over. and the charge that would have been presented to the grand jury and likely returned by the grand jury. You understand that?
Yes, sir.
Any questions for me about that?
No.
All right, so the court will accept the defendant's plea, find the defendant guilty of count 1, attempted robbery of felony of the 4th degree in violation of 292302 and 2911.0283, as well as count 2, disrupting public services, a felony of the 4th degree in violation of 2909.04A3. I will defer sentencing, order a pre-sentence report investigation, drug and alcohol evaluation, victim impact statement, continue defendant's bond at $250,000, cash surety or 10%, with an order that he have no contact with the victim in this case. Anything else for the record? Ms. Brown?
No, Your Honor. No, Your Honor.
All rise.